Okay, it is straight up 12 noon according to my clock. I'd like to welcome everybody to the Iowa State University Extension and Outreach Dairy Team Monthly Webinar Series. Continues today with Kristina Coutu, who's an attorney, and will review the common reasons that federal immigration officials may contact an employer or arrive on your farm. I remind everybody that questions can be typed into the chat box, and we will address those questions at the end of the presentation. Please note that this presentation is recorded and archived on the Iowa State University Extension Dairy Team webpage. And finally, I ask you to take a couple of minutes to complete the evaluation after the program, and that link will be provided when I send you the email that it has been archived. Today, Kristina will cover what ag employers should do if DHS shows up on the farm. Basically, best practice of what to do in a raid situation, or if ICE shows up or contacts the employer for some other reason. And the logical one is always an I-9 audit. Even though raids are what's on everybody's mind now, the I-9 audits are still very important because that is where ag employers could face liability for violations. Before the recent uptick in raids, I-9 audits were what we saw most of the issues in interaction with DHS. She will also cover I-9 compliance, what employer needs to do to make sure they are following the rules for new employees, and how employers can audit the I-9s they already have on file to make sure they are in compliance with the law. Kristina focuses her work at the Center for Agricultural Law and Taxation on researching and educating on current legal and tax issues impacting agriculture. As director of the Beginning Farmer Center, she brings her passion and commitment to supporting new farmers and providing resources for farm succession planning. She enjoys interacting with producers and agricultural organizations across the country. And before joining Iowa State, she was a practicing agricultural attorney. And she is also a fourth-generation dairy farmer and farmed full-time for many years. As I always say, Kristina, the podium is yours.
Thank you, Fred, both for the nice introduction and also just for having me here today. I want to welcome everybody who's joining us online, for taking time out of your busy day to spend a few minutes here discussing a pretty important issue that agricultural employers are facing today, and that's how to handle immigration enforcement actions and how to prepare for it as well. My contact information is listed here on the screen. I'm also going to have it at the very end if you don't catch it. As Fred mentioned, we'll have some time to take some questions that you can put in the chat or the Q&A box. But if there's questions that you think of later that you'd like to contact me, my email is there on the screen. Feel free to contact me and I will do my best to get you the resources that you need. Today's webinar is for educational purposes only. It is not intended to be legal advice and it should not be considered legal advice. However, there are attorneys who specialize in employment and immigration matters. And these are the attorneys. These are the folks that you should be contacting with your specific questions, because they can give you advice on your situation. And as far as best practices that you can implement out on your farm or help you manage through a potential enforcement action or an I-9 audit that we're going to talk to, or other reasons why ICE may visit the farm. We're going to cover some key topics today that are mostly based on questions that have been coming up as a result of recent discussions on enforcement immigration enforcement activities out on work sites, including farms. And some of the questions that have come up are, why would ICE visit a farm? What happens when ICE shows up at the farm? And what, most importantly, maybe, what can employers do now to prepare for a situation if ICE were to visit? Throughout this webinar today, I'm going to provide some links to where you can find additional information. We have an hour. We're going to fly through a bunch of topics, and the purpose is just to highlight a few key areas that you should have in mind, or that employers can have in mind when thinking about what an emphasis on immigration enforcement means in the farm context. To start with, let's just look at the agency structure that is going to determine who might show up at the farm when we're looking at immigration enforcement. So we can see on the screen here that ICE, Immigration and Customs Enforcement, is an agency within the larger Department of Homeland Security. Often we see DHS and ICE interchanged as far as how they're referred to in certain situations. And sometimes I think it causes a little bit of confusion. But ICE is the agency within DHS that is charged with the responsibility of ensuring I-9 compliance out on the farm. There's also other agencies within Department of Homeland Security as well that are listed on, a couple of them are listed on the screen, including USCIS and CBP. Both of those agencies could also jump in and assist ICE in immigration enforcement activities out on the farm, but their primary obligations are otherwise. I also have listed on the screen U.S. Department of Labor. So U.S. Department of Labor is not a part of DHS. It's a whole separate department. And within it, we have the wage and hour division. And the reason why I list this on the screen is because it is possible that wage and hour could be also involved in I-9 compliance. Although, again, what we're going to usually see is ICE, and that's how I'm going to refer to throughout the webinar today. However, employers who have already engaged with a federal agency involving employment laws, they most likely have engaged with Department of Labor and Wage and Hour Division. And the reason why is because Wage and Hour Division is charged with enforcing employer compliance with some other major laws that pertain to employment, including the Fair Labor Standards Act, that, among other things, regulates and governs minimum wage and overtime pay requirements. DOL, Department of Labor, is also involved with enforcement of the H-2A program, with compliance with the H-2A program. So the H-2A program is a program that allows agricultural employers to bring in workers on a temporary basis from outside the country to engage in agricultural activities. That is a heavily regulated program. It has heavy compliance issues that are involved with it, and employers who are involved in the H-2A program most likely have dealt with the Department of Labor. Reasons for ICE to come to the farm. There's a few that I have listed on the screen in order of likelihood that they would come to the farm for this reason. The first one is an I-9 audit. So an I-9 audit happens because ICE, in its charge of being responsible for enforcing I-9 compliance for employers, has the authorization to come out and audit an employer's I-9s to verify that the process is being done properly and forms are being completed as they should be. Now, this can happen or be initiated by ICE coming to the farm and hand delivering a notice of inspection that this audit is going to be happening. However, it's more likely that an audit is going to be initiated by a letter being sent to employers that states that the audit is going to happen. Employer needs to provide documents to ICE within 3 days, so that ICE can then go ahead and perform an inspection on those documents and other information that employer is required to provide. Another reason, separate from an I-9 audit, that ICE might visit the farm is to detain a specific individual or individuals. This is probably the second most common reason why ICE officials might come to the farm. The third reason is a raid. And that's usually something that is broader in scope, that several agents are going to come to the farm, and the process or the goal is to do a broader search and talk to a wider number of employees. So we're going to talk first about an I-9 audit and what that might look like. To start with, employers have a responsibility under federal law to not knowingly hire, recruit, or refer for a fee an individual who's not authorized to work in the US. The law also prohibits employers from continuing to employ a person, knowing that that person is not authorized to work in the United States. Employers are also required to verify for each new employee the employee's identity, employment authorization. And how an employer does that, and what is an employer is required to do, is complete a Form I-9 that verifies the employee's identity and employment authorization. An I-9 is required for all new employees that are hired after November 6, 1986. The failure to comply with the I-9 process, so either to not be obtaining forms at all, or even to not be going through the I-9 process and completing the forms properly, can lead to civil sanctions for the employer, and in some more severe cases, criminal sanctions as well. But even the civil sanctions or financial penalties that employers can face by not properly going through the I-9 process can be pretty, we're going to see it in a few screens, can be pretty hefty. So there's a financial incentive for employers to make sure that their I-9 process is being done properly, so to avoid any violations or fines that could occur. As we said, ICE is the agency that's responsible for enforcing the employment eligibility verification requirements that the employers must go through. Under the laws that govern the I-9 process, there's also provisions that prevent discrimination from occurring within that process. And certain things that can be considered discriminatory practices that the employer may not engage in are things like requesting more documentation than is required under the law. So basically going beyond what the law requires, or an employer requiring specific documentation that from the employee, rather than allowing the employee to choose to present from the list that we're going to see in a minute, that provides a list of documents that the employee may choose from to provide to the employer. If employer are going beyond what's required and engaging in these practices, those can be considered discriminatory, and are not allowed under the anti-discrimination provisions within the law. We're going to look quickly at a Form I-9. I know the font is really small, but I wanted to lay out on the screen so you could see the different pages that are included. For the first page there is the actual proper I-9 itself. It's where the information is going to be completed by Section 1 by the employee and Section 2 by the employer. This second form that we have on the screen, you can see it's the list of acceptable documents. So as part of the process, and a new employee is required to present to their employer documentations that show their identity and their work authorization. And they're allowed to provide either a document from List A, or they can provide two documents, one from List A, one from List B, and then one from List C. As mentioned on the previous screen, employees have the choice of what they want to provide from the list of documents that are presented there on the screen, and employers cannot require that specific documents are presented to them. The last two pages there are supplements that are going to be used in specific circumstances if they occur, as we're going to see on the next couple screens. Note that on the bottom of this screen, I have a link. It's www.uscis.gov/I-9-central. This is a repository of information that USCIS has put on their website that pertains to the I-9 process. At that link, employers can find the most current version of the I-9 form there that you can access, as well as prior versions as well. There's also the instructions are provided and other guidance that employers can take a look at and reference with questions or or information that will help go through the process. One of the things that is included on I-9 Central is specific information about doing a self-audit, and that's something that we're going to talk about in a little while. But knowing that that information is there to access is helpful in providing some of the detail that we're not going to be covering today. So here's the blown up version of that page 1 of the I-9. The employee is required to complete section 1 by the first day of employment. So the employee goes through and based on the instructions, fills out the required boxes or information that must be filled in section 1. Not every single box needs to be completed. There's certain boxes that are required and certain boxes that are not required. The employee is going to complete the information and then is going to sign at the bottom and date. And signing, I blew up the information, but the employee is going to be certifying under penalties of perjury that the information is correct, that they're providing and accurate, that the information that they're providing on section 1 is correct and accurate. Section 2 is the employer section. This is where the employer then has the responsibility to go ahead and look at the documents that the employee is required to provide within 3 business days of their first day of employment. The employer is going to review those documents, examine those documents, and enter the information on Form 2 as required. And then the employer is going to sign off on the document and also attest under penalties of perjury that the employer has examined the documentation that the employee presented, that the document appears to be genuine and relate to the employee named, and that the employer, to the best of their knowledge, agrees or attests that the employee is authorized to work in the United States. The employer, again, must complete this section within 3 business days after the employee's first day of employment. However, if you're hiring someone on a real short-term basis and you know that it's going to be a short-term basis for less than 3 days, then that information must be completed on day 1. Just a little more detail about what the employer must do, what the employer's responsibilities are. So the employer must make the instructions for the Form I-9 and the list of the documents that the employee may provide needs to make those available to the employee. So the employee has the instructions and knows what documents they can choose from to provide to the employer. The employer must make sure that the employee completes section 1. The employer does not touch section 1. The employer completes section 2 within the requisite time frame that we discussed on the previous screen. One thing that I didn't mention on the previous screen, and you can find this on I-9 Central, is that the I-9 itself, employers want to be using the most current version that's available. Periodically, the agency will go through and update the I-9 form. When it does that, then there's a new document, a new version that's accessible for employers to use. Usually during that time, there is a period where prior versions can also be utilized for a certain amount of time. But again, when hiring new employees, the employer wants to go and verify that the document that they're using is an acceptable version and most likely the most current version that's available. Section 2, again, that's the employer portion. So it might be you as employer or one of your employees who's engaging in the I-9 process on your behalf in relation to new hires. So employer needs to examine the documentation that the employee presents and determine whether they reasonably appear to be genuine and relate to the employee. Again, employees choose which documents to present as long as they're acceptable within the list of allowable documents that can be presented for these purposes. And the employer should not reject acceptable documentation due to a future expiration date. So it's possible that there is an employee who has work authorization for a specific amount of time, and that work authorization could expire. If that employee is still working for you when that expiration date is coming up, it's the responsibility of the employer to make sure that that work authorization continues, and to ensure and to document that on one of the supplements that we're going to talk about in a second. So if an employee has work authorization that is going to expire in the future, that's not a reason for the employer to reject that documentation. If it is, if the worker is authorized to work now. The supplemental forms, there's two of them, and they're used for specific circumstances. Supplement A is the preparer and or translator certification. This is used if someone helps the employee complete section 1. And help can take a couple of different forms. It can be translating the I-9 for the employee. It could also look like or be where someone helps complete the form, as in fill in the information on the form as directed by the employee. If that happens, then the person who's doing the assisting needs to complete supplement A with their information. However, this doesn't relieve the employee from signing off, again, under penalties of perjury, that the information is correct in section 1. Even if the employee receives help, they're still going to be signing section 1 and dating it. Supplement B is used for a different purpose. And so we talked about this a little bit on the prior screen, but if an employer needs to re-verify work authorization for an employee, this is where that would be documented. There's also situations where an employer could use supplement B for an employee who maybe has left employment but then is rehired within 3 years of the date that the I-9 was originally completed. This is an area where if you're working with an attorney, it's good to have the discussion on what your practice should be, because employers have the choice of either using this process for rehires or just simply requiring a new I-9 for everyone, including employees who may come back to employment, even if they're within this 3-year window. With any policy, it's important to make sure it's applied consistently across the workforce. And again, this is a good thing to have a discussion with an attorney to decide what process works best for your farm. The law requires employers to retain or keep I-9s on file for a specific period of time. And what that time frame is 3 years after the date of hire or 1 year after the date that the individual's employment is terminated or the employment ends. And it's the later of those two dates. Employers are not required to keep copies of those documents that the employee presents, that the employer looks at to verify, identity and employment authorization. There's different schools of thought on whether copies should be kept. I think the most important thing is to make sure that any policy you have is, again, applied consistently. So if your policy is to keep copies of those documents, make sure you're doing it for all employees. And if the policy is not to, make sure that you're not keeping it for all employees. When policies are applied inconsistently, that can lead to claims of discriminatory behavior by the employer. And so it's important just to apply any policy consistently across the board. This is also an area where it's a good idea to talk to, if you're working with an attorney, talk to them as well to get their perspective on whether you should keep copies. I don't know that if I mentioned it a couple of slides ago, but even if your process is to keep copies, and you're doing that, that does not mean that when you as the employer or whoever's filling it out on your behalf of the employer may look at the copies of the documents to fill out that section 2 of the I-9. In fact, you can't do that. When the employer when you're looking at those documents and completing section 2, you have to be looking at original documents and putting that information onto section 2 of the I-9. Now, when would an audit occur? As we mentioned, ICE is the agency that is charged with making sure that employers are complying with the requirements of the I-9 process. And as such, ICE has the authority to come in and inspect I-9s to verify that compliance. That audit or inspection is going to begin with a notice of inspection. We mentioned at the beginning, this could be a reason why ICE would show up at the farm in person. However, very often this notice is going to be delivered to the employer by mail, and that's what's going to initiate or alert the employer that the audit has started. The law requires that employers have at least 3 business days to produce the Form I-9 that's requested in the notice of inspection. An employer can waive that time and turn over the documents earlier than that, but most attorneys would likely advise that, instead of waiving that time, use that time. Use that time can be used for something useful, can be used to review the I-9s that are being requested, compile the I-9s, making sure that you have an I-9 for all your employees. Hopefully for easy access, you have one file that contains all the I-9s of current employees, and then another file that contains terminated employees that you keep for the requisite amount of time per the retention policy that's required. But in the case that you don't have that, and that perhaps an I-9 is included in a personnel file or another area, taking that time to make sure that you have all the I-9s in place that you're then going to present to ICE to inspect is pretty important, because they're also going to request other documentation as well, including a couple of things that I list here, which is the employer's payroll, and a list of active and terminated employees, which they'll then use to verify against the I-9s that were presented. It's also possible that during that time, you can review the I-9s, and if there's problems that are identified by you, or hopefully if you're working with an attorney in conjunction with the attorney, can determine if those are issues that can be corrected. And if they can be, making sure that the appropriate process is used. Or even if they're not corrected, identifying what those issues are, and then working with your attorney to decide whether to proactively let ICE know that, hey, we took a look at these documents. We know that these deficiencies are noted, and we have a plan to make sure it doesn't happen in the future. In general, and we're going to talk about this more in the self-audit context, but if a correction is ever made to an I-9, the best process is have it done under the guidance of an attorney, or at a minimum using the guidance that's presented on I-9 Central in the self-audit section and the section on how to correct mistakes. But general rules are, you never want to try to conceal, backdate, or hide anything. And so any corrections that are going to be made they need to be very transparent. As in, if there's incorrect information, striking through initialing and dating when that change is made. Any attempt to backdate, conceal, hide during a self-audit or any other time could take something that is potentially a technical violation that may have a smaller penalty or potentially no penalty at all, and it could now shift that into the category of fraud or fraudulent activity, or at least the indication of fraudulent activity. And that is not where any employer wants to be. So throughout the process, transparency and making sure not to conceal, hide, or otherwise backdate any change is really important. So ICE will go ahead after the I-9s are provided. They'll go ahead and inspect the I-9s and determine whether there's any violations. If you're working with an attorney, they can help through this process in communicating with ICE as far as not only submitting the documents and when and where ICE will review them, but also as far as if there are problems that result from the audit, if there are findings, how to manage through those as well. So potential violations and penalties that can be found. There's technical or procedural failures that can be found. There's also more substantive violations that can potentially occur. Even for paperwork violations, I just want to point out some of the fines that can apply. So there's a range here we see for paperwork violations that can go up to as high as $3,000, almost $3,000 per violation. And these penalties, the amounts increased recently. Now, the reason there's a range is because there is a process that if there's violations that ICE would go through to determine what the actual amount of the penalty is. And there's a number of factors that are going to be taken into consideration, including whether there were past problems that the employer had with I-9 compliance, the size of the employer, the number of problems and that are found, and other things as well. Those are all going to go into determining what the amount of the fine could be. When we get into the category of knowingly employing unauthorized workers, we can see there that that can result in much higher penalties. And in certain situations, again, taking into the different factors, as far as a specific employer, could even result as high as almost $30,000 per unauthorized worker. And then, as we mentioned earlier, there can be criminal penalties that can apply in certain situations. This usually would apply if there's indications of fraud or certain patterns of practice that violate the I-9 process. So having gone through really high level that the employers have significant responsibility in the I-9 process, pointing out, remembering that the I-9, it's important to remember that while it's part of, the onboarding process that employers have for employees, we need to remember that the I-9 isn't just another onboarding document. It carries significant responsibility for the employer, and the employer should look at the process that it has in place, in light of that responsibility and the potential problems or penalties that arise for noncompliance. So in thinking about all that, what can be done now? And what can be done now is employers can look at what their policy or what their process is for I-9s currently, and making sure that there's a compliance policy in place if there isn't one already. And if there is a policy in place, reviewing it to make sure that it's effective in ensuring that I-9s are being properly completed and that compliance is happening. So some of the key areas that are included in a good compliance policy include designating a key person or people who are responsible for I-9 compliance. And this can look a little different depending on what your farm looks like, how many employees you have, whether you have different work sites. But having at least one person who is trained and who is knowledgeable about the whole process is an important part. But then also thinking about if there's other people who are engaging in the I-9 process with new employees, maybe at a different worksite location, or such, that making sure that those individuals are trained as well. And if there is a process that's happening at potentially different work sites, that there's consistency among your whole operation. And so training personnel who are involved in I-9 on the onboarding process and when an I-9 is required and the time frame for it. Ensuring the correct version is used. Again, there's that link to I-9 Central, which is going to provide the most current form and any other acceptable versions that can still be in use. How to review the documents that the employee provides and make sure that the employer portion is completed properly. And then also re-verification requirement and process in case there is that need, in addition to understanding the retention policy and making sure that I-9s are kept for the requisite amount of time. However, also keeping in mind that once they're available to be purged from the file, that's a good practice as well, so that there aren't unnecessary documents that are being kept that can then be inspected. And then also considering, as part of the compliance policy, conducting a self-audit. I talked about this a little bit already, but a self-audit is essentially when the employer goes in, not in an audit situation, and takes a look at the whole I-9 process and specifically the I-9s that have already been completed, and to determine if there are any problems or if there are any errors or if there is any missing information, and then determining what to do from there if those issues are found. During a self-audit, it's not uncommon at all for employers to work with an attorney in this process in a couple of different ways. One, could be just getting advice on their I-9 process overall, and then advice on how to conduct a self-audit, or it could be that an attorney is actually themselves going through and reviewing the documents in a non-audit setting for their client, for the employer, to determine if there's any problems or deficiencies. But either way, what's important is to review the I-9s. If there's error, correct the errors that are able to be corrected under the guidance or with the advice of an attorney, or at a minimum, using the information that's on I-9 Central on how to properly make corrections, again, ensuring that there is no indication or efforts to conceal information or backdate information or hide information. Employers can also consider using E-Verify. Some states require E-Verify for all employers or for employers in certain employers in certain situations. Iowa is not one of them. So if you are not using E-Verify and considering using E-Verify, there's certain pros and cons that you should consider, and consider how those relate to your farm and your employment operations. We're not going to talk about all of those today in the short time that we have, but I do just want to point out that E-Verify could be a good fit for some employers and it may not be a good fit for other employers. So if you're considering it, make sure you do the work to talk with someone, understand what the full responsibilities are, and then you can choose whether it's a good fit for you or not. We're going to switch gears slightly now for the rest of the webinar and move away from the I-9 audit process that we've been talking about, and instead talk about two other reasons why it's possible that ICE might show up out at the farm. And I mentioned these at the beginning of the webinar, but as a reminder, they are to either to one, detain a specific individual or individuals that ICE has already identified, or two, to show up in the event of a wider or broader workplace raid. When thinking about both of these reasons why ICE could show up out at the farm, it's important to think about what ICE would need in order to conduct a certain type of search. So in order to conduct a search of non-public areas, so a broader search, ICE is going to need one of two things. They're either going to need a judicial warrant, and there's a few different warrants we're going to talk about in a minute, or they need to have the consent of the employer or who they're engaging with out on the farm when they are there. Here's an example of a judicial warrant, just to take a look at what this might look like. As you can see in the highlighted areas, it's issued by a court, it's signed by a judge. For a search warrant, it's going to specify specific information, including the address where the search can occur, a time frame and a date of when the search can take place, and also the scope of the search that can be conducted. Now, in contrast, what's showing now on the screen is a different type of warrant, and this is an administrative warrant. And this is something that is likely that ICE could present at the farm. This is different, not issued by a court or signed by a judge. Instead, it's an agency form. And you can see in the highlighted area of this sample form that this one is U.S. Department of Homeland Security. So it's a DHS form. It is again signed by an administrative officer, not a judge, and it doesn't authorize the search of non-public areas. Unlike the judicial warrant we just saw, which does authorize within the certain scope of what's listed on the warrant, a search of private areas or non-public areas. So knowing that ICE could arrive at the farm unannounced in these situations that we just discussed, and knowing that there's specific warrants that are required to conduct certain types of searches, what can employers do now to prepare in case this type of unexpected visit occurs on the farm? And the biggest thing that an employer can do is, or the best thing maybe that an employer can do, is create, or if you already have one, review an internal plan or protocol that you would put in place and that you would train your employees on to handle the interaction in case ICE does arrive out at the farm in this unexpected context. Part of that is going to be looking at areas that are on the farm that can be clearly marked as private areas and making sure that they are marked as such. We're very used to, in the livestock industry and agriculture, for other reasons, limiting access. For biosecurity reasons is one area where we're accustomed to limiting access or preventing access or having certain protocols in place before certain areas can be entered. this is similar, but looking at it from this context of what we talked about, it's can be a good idea to go look at the workplace, look at the farm, look at the areas that are considered private or non-public access areas, and make sure that they're designated as such. Also consider looking at an area on the farm that is very limited and kind of private for officers where you could ask them to wait if an officer arrived at the farm. You've seen the identification that they've presented to you. Potentially, they've presented you or whoever your delegate is at the farm with a warrant, and you're reviewing the information in that warrant to determine what it includes. Potentially, sending that to your attorney if you're working one so that they can weigh in as well as how to proceed. Is there an area while you're doing that you could ask officers to wait? And it's an area, when I say private in this context, I mean someplace that's kind of separate from the overall flow of what's happening on the farm. Is it an area that doesn't have access to documents that are just laying around that, they really don't need anything to look at, or having employees or other individuals walking in and out that they may have the opportunity to question while you're reviewing the warrant after they've arrived. And that can all be part of a plan that's created. An attorney can be really helpful in helping not only handle the enforcement action or the visit if it happens out on the farm, but also in helping you create a protocol or a plan that works specifically for your farm and for your operation, considering the physical layout, considering how many employees you have and where they're, where the general flow is for employees of where they're working. Internal plans or protocols often include some key factors. Now, there is quite a bit of information online that different groups are putting out, that some law firms are putting out, and they're going to cover the key areas of what can be included in a really good protocol or an internal plan for handling a visit to the farm. And some of that is what I'm covering today, just some of those real basic highlights of what can be important to include in a plan. But remembering all of that, including what we're looking at today, remembering that those are all just really high level categories. There's nothing that's going to replace looking at and developing a plan for your specific farm, considering all the unique qualities that apply to your place, and working with a professional and an expert in that area who can help you develop a plan that's going to be most efficient and most effective for you. But some of the key important parts to include in the plan are as follows. One of them is identifying and designating a person, and then also a backup in case that person's not available, as that point of contact to engage with officers if they arrive at the farm, and training that person to be able to handle the communication. Not only training the person and designating the person, but making sure that the person that you designate is of a temperament that they can have effective communication in this situation. Remembering that if officers arrive at the farm, it's going to likely be unannounced. So even though maybe you prepare for it with a plan like we're talking about, it's going to be a surprise on that day. And as things go, it's probably going to be on the day when it's the worst possible day for you on the farm because of a million things happening on that day, because that just seems how things go oftentimes. Now, is that person someone who can handle that situation in a calm, professional manner? When the officers arrive, depending on what the context is and how they're arriving, they may be dressed in their enforcement garb. They may and likely will be armed, and that can be unsettling, when that surprise visit occurs. But can your designated point of contact communicate in a calm, professional manner to ask the officers for their identification if they haven't yet provided it, to ask for a warrant if they're intending to do a search, making sure that that designated point of contact knows that there's different warrant types and the basics of what those different warrants provide and allow for. And also making sure that that person who you have designated can get in contact with your attorney if you're not available to be the person who gets in contact with the attorney, to make sure that the attorney knows in real time that this is happening and this is happening right now, so that the attorney can be in the best position to review the warrant or any other information that ICE is providing and be able to guide you through the process effectively as possible. It's also important for a plan to not only include identifying and designating that person who's going to be the contact to deal with officers who come from the farm, but also training the rest of the staff, the rest of your employees on that there is a designated contact person. So if for whatever reason another employee ends up being the first line of contact if an officer arrives at the farm, that they know who the designated person is, will have the communications, and they know how to get in contact with that person or the backup person if that person is not at work that day, and that employees know that they can say, "Hey, I don't have the authority to permit access here, but I am going to contact the person who does." And hopefully then asking the officers to wait in an area that you've already thought about where they can wait, where they don't have access to, documents or other information that they don't need to see, or employees walking in and out. Now, another important thing to consider is, do you have someone who would be able to document what happens when ICE is out on the farm if they come for a visit? While employers and your employees cannot impede in any investigation or in any process, and they can't hinder it or get involved in communications that are happening if ICE is questioning employees, they can document what's happening in a general sense, as in where the officers are looking, who they're talking to, and if they're taking any items, what they're taking. Employers can also ask ICE if they have taken items and removing them from the workplace. Could you please give me a list of what's been taken? Another thing that can be done and could be done, immediately, regardless of where you are in the planning process as far as an overall plan, is maintaining an updated list of employee emergency contact information. So in the event that an employee was detained, that you would have the most updated information of a family member or other emergency contact that you could inform that the employee was detained by ICE. Also thinking about preparing is considering what's the employer's role when it comes to ICE talking with employees. So we already said that you can't impede in that process. You can't prevent that process or get in the middle of it. And in no circumstances with anything that we're talking about today, should the employer, any employees try to get into a physical altercation or otherwise physically prevent ICE from proceeding with a certain action. But what employers can do is they can provide employees with either information in a training context, or maybe even better, let employees know where they can get information about what their rights are. And once employees have the information, then it's up to them on how they want to respond to ICE questioning. Employees do have the right to remain silent. However, you as the employer don't want to be telling them, either how to respond to questions or to not respond to questions. Likewise, employers don't want to be telling employees to, flee from the work site or anything else like that if officers do arrive at the farm. Employers don't want to be hiding employees or engaging in any of those types of activities. Now, if employees are detained, employers can ask officers, and it can be helpful to do this, to ask officers for information about where the employees are being taken. And the reason why this could be important is in certain contexts, if an employee or if an individual is detained, they may be brought to a certain location and then they may be moved to another location. And so getting the information from the officers of where the employees are being brought, where they're being detained, will allow you to then provide that information to the employee's emergency contact, their family member, or other emergency contact that they've designated. So we've covered some really broad issues from a really high level. And the point of it was to raise some awareness on some things for employers to start thinking about as employers are are hearing about enhanced immigration enforcement that's occurring. So key takeaways are employers should prepare for increased enforcement so that if it does occur, if an event that we've talked about today does occur on the farm, there's at least a plan in place and it's not completely unexpected. With an emphasis on immigration enforcement, employers should consider their responsibilities under the I-9 process. And in doing in doing such, be prepared for an increased amount of I-9 audits. Employers should take a look at what their process is right now. And if there's deficiencies or problems in that process, obtain the information that's needed and provide training to make sure that employers are in compliance with the I-9 process. Conduct a self-audit of forms that are already on file and determine if there are any problems. And if there are problems, look at what can be corrected using the proper technique to correct errors or problems. Preferably, ideally, working with an attorney for that guidance and how to correct errors that might be found during a self-audit, or at a minimum, using the information that's on I-9 Central that discusses an audit and how employer can correct mistakes in a way that is not going to be perceived as fraudulent by concealing information or backdating information or trying to hide information, doing everything in a very transparent way. Also, just considering the different types of searches that could occur, taking a look at the workplace, taking a look at the farm and seeing if there's non-public areas that can be clearly designated as such. And then finally, from an overall perspective, doing what we were just talking about, implementing a plan for how it would be handled if officers did show up at the farm. This is not going to make this a non-stressful situation having a plan, but it can take some of the uncertainty out of it and give you as the employer a little bit of control back in the process by designating the person who would have the contact with officers, knowing that that person knows how to handle the interaction and not escalate the situation. And be able to determine what the officers are asking for and communicate with your attorney in order to get guidance in that way as well. So again, these are all just real high-level things to think about that you could implement in your workplace or out at your farm, as we're in an area where there is potentially there is the potential for increased audits or increased enforcement with officers showing up at the farm. With that, I am going to stop talking and we're going to answer some questions.